Welcome to Goodwin Law Unplugged, Florida real estate and more. This podcast features candid insight from real estate industry professionals from all sectors. Your host, attorney Matthew Goodwin, a native Floridian and experienced real estate attorney, will provide his personal insight on legal matters and feature other professionals offering their candid advice. Whether you're a first-time homebuyer, seasoned investor, or experienced real estate agent, there is something for everyone. Thanks for joining us on Goodwin Law Unplugged.
Well, welcome back, everyone. Charlie McDermott here once again, producer of Goodwin Law Unplugged. And there would be no Goodwin Law Unplugged without Matt Goodwin. Matt, how you doing today?
I'm good, Charlie. How you doing this morning?
I'm doing terrific. And holy cow, most of my podcast clients, show co-hosts, they come on board and, they have important stuff to talk about. But what you sent for this show, listeners, buckle up, man. You have some important stuff to cover. And this, I believe, I think you mentioned, it's going to be a series of episodes regarding, these important, I guess, what I call frequently asked questions about title and what's going on in your world on the legal side. So what do you have in mind for this first podcast series, technically episode 11, Matt? You're in double digits here.
Yes.
But for this episode, what do you have?
Well, it's been a while since we talked and been in the studio, and I want to start a series of the frequently asked questions on the Florida Realtors as-is contract, because we seem to get the same questions over and over, and every time a big event like a hurricane comes through, people forget how the standard contracts operate because you get stuck in the details. So we're going to talk today about the basics first. When does it become a binding contract? Talk about offer, counteroffer, and acceptance and how that works. Then we're going to talk on the next episode about effective date. So for starters, the Florida Realtors contract is used, I'd say, in more than 90% of transactions in the state of Florida. So if you buy or sell property, your chances are really good that you'll work with it, whether you're a real estate agent, experienced or not, an investor, or someone buying or selling real estate. And the as-is contract is the most commonly used form. These concepts that I'm going to go over on this episode apply to contracts in general, but there's certain things in the as-is contract that and they're also in the standard contract when it comes to offer, counteroffer, and acceptance. So just to jump things off, the contract says time for acceptance of offer and counteroffers, effective date. This is paragraph 3A of the Florida Realtors FAR/BAR as-is contract. It says, if not signed by buyer and seller and an executed copy delivered to all parties on or before such and such date, this offer shall be deemed withdrawn unless otherwise stated. Time for acceptance of any counteroffer shall be within 2 days after the date the counteroffer is delivered. So we're going to start with a question. So the seller signed the offer prior to the time of acceptance established by paragraph 3, but failed to deliver it to the buyer until after the expiration of the time of acceptance. The question is this a contract? So we're going to dissect this a little bit. We have a buyer that makes an offer. The seller signs the offer before the time of acceptance in that date field that was filled in paragraph 3, but he never delivered it to the buyer. The seller never delivered it to the buyer until after the time expired for acceptance. Is there a contract? What do you think, Charlie?
Number one, I'm going to think for our listeners, and one is their heads are spinning, just like mine was when I got you involved in my recent transactions. And we talked about this in previous episodes, the importance of bringing someone in with expertise, whether it's you and your firm or someone else on the legal side. But from a, what do I think? I've been involved in this long enough to know what I think doesn't matter, that I always leave it to the professional and say, hey, I don't want to know an opinion. Well, I don't want a friend's opinion. I want someone who knows the law and can make that decision. So I'm going to turn it back to you, Matt.
I appreciate that, Charlie. That's a topic for another day on unauthorized practice of law. And so good job bouncing that back to me. That's what realtors should do when their buyer or seller asks them that same question. Engage an attorney. The answer is there's no binding contract, because this contract requires that, remember, I first read this, delivery. And if the delivery is not made until after that expiration date, then the offer is considered withdrawn, period. Now, there might be some other questions churning in your mind. Give me another scenario.
Well, and this is something, again, this is so cool. It's so recent in my mind. Buyer made an offer on the property with a time frame acceptance date of 3 days from now. So let's just say, what if the buyer finds another property and wants to make an offer on something else? Can they?
They can, but they have to do something else first. First, they have to withdraw their offer. So you can leave an offer open-ended or closed-ended. In this case, there's a deadline to acceptance. But if the seller has not delivered written acceptance of the buyer's offer, the buyer can still withdraw that offer. They must officially do that. Now, there's a lot of this going on over the last few years in Southwest Florida, where buyers will use the as-is contract to make multiple offers on properties just to see which one will get accepted, so they're the first one in. And what this creates is buyers are finding themselves in multiple binding contracts that it's impossible for them to perform on. And they're relying on the as-is provisions that give them the unilateral right to terminate during that inspection period. So sellers got smarter, and the tides changed a little bit, and the realtors up their ethics games as well and coach the buyers. So to answer the question, if buyer made an offer on a property, time acceptance from 3 days, finds another property, wants to make an offer on that property, they must withdraw their offer on the first property, and then they can move on. And they must do it in writing.
Interesting. Yeah, and as you know, Matt, and for our listeners, we went through that. Not that particular scenario, but that was something that crossed my mind. We were in Fort Myers Beach. Hurricane Ian came in and devastated the island. And when the offer came in, and I think we had an as-is contract, right? If you can, you probably don't remember my specific contract, but one of the concerns I had during those 3 days, because I'm sure many other properties coming on the market, was, are they going to be just popping in offers in all these other properties? And it was good reassurance working with your team, knowing that, that can't be done, right? Did I get that right? Yeah.
That you did, but the lawyer in me says that can't be done unless you do something else first.
Yeah.
So it is still done, and that's why I'm going to talk about the as-is versus the standard contract in a later episode. It's very important, but this is the basics. A binding contract requires offer and acceptance in writing when it is for real property. There's something called the statute of frauds that requires contracts for real property to be in writing. And then your contract form that you use, for example, the FAR as is, has specific provisions governing how that offer and acceptance is to be conveyed, but it always must be in writing. So essentially it requires delivery, so you know that it's been accepted.
So that needs to happen within those 3 days.
It does.
Yep. Okay. So what if the parties start performing the contract and decide later that they don't want to proceed since they now think their contract is not valid?
That's a really good question. So see if I understand this properly. There's an offer and acceptance. The buyer maybe orders an inspection or something else. The seller allows them entry for the inspection, so they're performing under the contract. And later, somebody, buyer, seller, or both, decide they don't want to proceed since they now think their contract is not valid. Usually, this can really come up on either side, the buyer or the seller. I've seen it on both, and have been asked that question by both. There, you can sort of ratify the existence of a contract by your behavior. So if you behave as if there's a contract and there actually is an offer and acceptance, the courts may look at that as using a concept called the meeting of the minds, right? And then what would make this much more powerful or compelling of an argument that it's valid is whether the buyer actually makes their deposit. If the buyer makes their deposit, that's a huge indication that they believe there was a contract. And if they go beyond that performing, it's going to be really hard to get out of it. Now, there's an argument on both sides, and that's why you should have an attorney involved in these transactions. Because if you have a binding contract, you don't have legal counsel, and then something says it's off, then you have to hire a lawyer then. And that at that point, you're losing time. You've lost time.
So the actual deposit, how, does that have to be paid within those 3 days? Is that window there, or is that something that happens after that?
No, that's a good question. It can be paid anytime, but the contract in paragraph 2 determines when it's required to be paid. In the FAR bar contract, time is of the essence to make that deposit. So if the buyer has not made it in the time they promised to make it, then they're in default and the seller can get out. Okay. So typically we see 3 days. You don't see as many offers being made with the deposits presented at the time of the offer, but it does happen. And we'll talk more about timelines on a later episode and the significance of notice. So to take this to the next level, you have, we're going back to offer, counteroffer situation. So paragraph 3 provides language that speaks to what becomes a counteroffer. But rather than go into the language of the contract in general, if the offer's made and the seller changes any of the terms, adds, subtracts, or changes, then it becomes a counteroffer. The FAR bar as is contract makes that effective for 2 days after delivery of that counteroffer. But the buyer is no longer obligated to do anything unless they accept that counteroffer within those 2 days. So if the buyer is the offerer and the seller changes that offer, then the seller becomes the offerer and the buyer now becomes the one who must accept it in writing for it to be enforceable.
Okay. So to play this out, we have 3 days. Most deals aren't clean offer made, accepted. Usually it bounces back and forth. At least that's been my experience. So I'm the seller, buyer makes an offer. It's not the price that I agree to. So I counter with a different price. So at that point, let's say that's day 2 of those 3 days. Are you saying then that now they've gotten an extension really of two additional days to accept that?
That's exactly right. The buyer has 2 days that may go beyond that initial offer acceptance date. So that's how that works in practice.
Okay. So then if a seller counters a buyer's initial offer and then a second offer comes in, does that seller have to wait for the first buyer to respond to that counter offer before moving on to the second offer?
No. Remember, offer has to be withdrawn if they want to make an offer on a second property, so you treat the counter offer the same. Counter offer has to be withdrawn before they can entertain a second offer from a new buyer.
Okay. So in essence, both of them have to pull out legally, some kind of paperwork. Yep.
You have to have a written correspondence to either the buyer or the buyer's agent or the seller and the seller's agent in the case of the initial offer that is officially withdrawing your offer or withdrawing your counteroffer. It has to be in writing.
Yeah. All right. Now I'm embarrassed to ask you this question, but I think I need to. is the seller's verbal counteroffer with instructions to the buyer to write it up enforceable?
That's a great question. Regardless of what the contract says of written and delivery, you shouldn't be embarrassed to ask that question, because that question is asked quite often, and you cannot have a binding verbal counteroffer. Period.
Yeah.
So the instruction to write it up is just it's meaningless, it's not enforceable. But this happens so common where buyer says, I made an offer, I gave it to my agent. My agent called the agent. They said, yeah, we'll accept it. Just write it up. Or, whether you're dealing with a counteroffer situation, write it up. Well, until it's written up, it's not enforceable. And until it's written up and delivered, it's not enforceable. It's very important.
It brings to mind, I listened to Joel Osteen on, I guess, Sirius radio, and he often tells a story of buying the what's the center they're in. It used to be, I think, the Houston Rockets played there, and they bought it. But prior to I guess purchasing that property, they had two different deals in play, and it sounds like they were like there. Everything was agreed on. They're actually doing soil samples of the other potential properties. I'm guessing kind of a handshake deal with the owner, and they went in to finalize it. And the as the story goes, the secretary tells Olstein and his group, oh, the owner just sold the property yesterday afternoon. So I guess that speaks to the verbal versus the having a real enforceable deal.
That's what happens in reality. Just to read this paragraph one more time, and we're going to wrap up here in a moment. Paragraph 3A is what we're talking about. FAR as is contract, time for acceptance of offer and counteroffers, and effective date. We'll talk about effective date on the next episode, so be sure to tune in. The provision says, if not signed by buyer and seller, and an executed copy delivered to all parties on or before that date, this offer is deemed withdrawn. Unless otherwise stated, time for acceptance of any counter offers shall be within 2 days after the day the counter offer is delivered. So based on the contract language, there's no offer to accept after the time of acceptance has passed. And the buyer's offer is deemed withdrawn, and a party can accept a withdrawn offer. Now, the parties can state a different amount of time for acceptance of a counteroffer, but it's not commonly done, as most of the people writing up these contracts are not licensed attorneys, and they can't add their own custom language. That's considered unauthorized practice of law. Parties can also, there's misinterpretation about how these sentences work, the offer, counteroffer timelines together, addressing separate timelines for accepting an initial offer and a counteroffer. So it might be a good place for change of formatting or separating those timelines into their own paragraphs, because a lot of the confusion, or maybe if you're a realtor, just draw a line between the two, right? Or circle one and leave the other one, so that it draws the attention and to the relevant provision of counteroffer. So if you don't have any more questions, I'll wrap up. Really enjoyed talking with you about this today, and really looking forward to talking about that effective date.
Awesome. And just a shameless plug for Goodwin Law, because I know you have listeners all over the state of Florida, and you help folks all over the state of Florida. So for our listeners who want to learn more, go to FL, as in Florida, FLEstatelaw.com, and or get a hold of Matt and his team, 239-207-3403. Matt, we'll see you in the next episode.
Thanks, Charlie.
Thanks for listening to Goodwin Law Unplugged. To learn more about Goodwin Law and to utilize our services, visit GoodwinEstatelaw.com or call 239-207-3403. Hablamos Espanol. To submit questions or be a guest on a future episode, Message us on our website or on social media by searching for Goodwin Law PA in Naples, Florida. This has been Goodwin Law Unplugged. Thanks again for joining us.